We're going to have our guest pin this on a shirt so that we can have video, but I'm Liz Holland. I'm the president of the League of Women Voters in Collin County, and I really appreciate everyone coming to hear about the Supreme Court, past, present, and future. We start off every session with telling everyone that we, the League of Women Voters, is nonpartisan. We do not support candidates or parties. That does not mean that we are neutral. We are a political organization, so we focus on issues, and we do stand and advocate for many issues. With that, I'm going to turn it over to Susie. There she is, who's going to introduce our speaker. Can you hold this?
Thanks, Liz. Just to add my welcome, I'm Susie Marshall, and it's nice to see familiar faces and have you all here with us. I'm going to introduce Chris. Chris Tucker is a popular public speaker on social and political trends, pop music, the presidents, the Supreme Court, American history from the 20s to the 80s, and more. He's a former editor of D Magazine, a longtime writer for the Dallas Morning News, and a commentator on KERA radio. He's also taught history and politics at Richland College's Emeritus program. I was lucky enough to be one of those that took several of his classes and thoroughly enjoyed it. He's a wealth of information, especially on current events, and is always entertaining. So let's give him a warm welcome. Let me just add a few more things. You should all have a handout. If you don't, there's some extras in the back. I know at every meeting that I've been in lately, they've said, please silence your phones. So I'm going to ask you to do that. Please silence your phones. And if you have any questions, feel free to ask them. If you can wait till the end, fine. If you cannot wait until the end, go ahead and ask. He's very open for questions. Okay. This is for the video, and this is, I don't know that you need to hold that. I can probably hear you.
Can you hear me?
Yes.
Great. Okay, we only need one microphone then. Is this working for you? Is this what you need? And if I could just get it clipped on here. That good? That good? Okay. All right. Okay, well, we don't need this. Thanks so much for coming out on this chilly morning. I guess it's seasonable weather. I started to say unseasonable based on the last 2 weeks of heat, but I guess this is what February is supposed to feel like. And besides that, we get a chance to recite the Texas weather poem. Do you know that? Texas weather poem? We never complain about a chilly day because we know August is on the way, okay? All right, so that's how we got to keep it today. Thanks so much for having me back to speak to you today. I really enjoyed being here a few months ago, actually at another location a few months ago, to talk about the parallels, some happy, some sad, between the roaring 20s and these are certainly not the snoring 20s, are they? But our time today. It's a privilege to speak to a group that does such important work as you do. It's always been an important task that you carry out all the time, and maybe never more important than it is today. So we're going to talk about the Supreme Court, sort of past, present, and future structure. I've got important cases from the past. I've got some good information, I hope, on how the Supreme Court came to be in the first place, which some people are still wondering about. And by the way, I just noticed something. Those are actual voting machines back there that haven't been seized by anybody yet, have they? I mean, so I guess that's going to happen later. I don't know. But okay, so let's. We're not going to go over every line of the first page or two that you have there. This is just kind of for your information, just in case you want to know who these people are, how they got on the court, who put them there, how long they've been there. A lot of info. Now, I got to tell you something, though. We're not going to tell the justices this, okay? But they're all about 6 months older than it shows here. This is the most recent one I can find. So they've each had a half-year birthday. And we'll talk about some of these folks as we go through today. Clarence Thomas, for instance, being almost the longest-serving justice. That might have something to do with whether he wants to stay on or retire. We'll touch that question later. So then the question is this. How do judges justify their judging? How do they, what is their thinking rooted in? It can't just be, well, on Monday I felt this way, and on Wednesday I felt that way, even though sometimes it might look that way. So we have these different philosophies of judging. And some of them are sort of neatly paired opposites, but when you look at them a little more closely, they're not that neat. There's always this question of, are judges just making up the law? Are their philosophies rooted in something that's real that we can understand? Or is it just more of a, nah, that's the way we saw it? Judicial restraint, for instance, is a belief that most of the time, judges and the justices of the Supreme Court should respect and not second guess laws passed by state and local governments unless they are clearly unconstitutional. Now, the Constitution, we're going to talk a lot about it today. This is my handy-dandy copy of the Constitution, once given out in a county court at law to jurors by a judge who's no longer on the bench, but that's okay. Whenever we get to the question of interpreting the Constitution, people always say, I want a strict constructionist. I want somebody who'll just look at the Constitution and tell us what it says right there, where that little mark is, and that's what we ought to be doing. Well, the problem is, it's not always that clear. This happens to be 46 pages here of the Declaration of Independence, the Gettysburg Address, the Constitution, and all the amendments in 46 little pages. Now, that might give you a hint that the answer to not everything in the world is found neatly laid out in these pages. And that sometimes calls for judges to do some sort of extrapolating. All right, this is what the founders said about this. We think they might say this today about this, even though this may be a case that they could never have had an inkling of. As smart and wise and far-seeing as the founders of this country were, there were many things they simply could not have foretold. I'll give you a good example of one as soon as we get through this list here. Now, judicial activism is the sort of opposite of judicial restraint. This is the idea that judges have a role in public policy. They're not simply interpreting a 200-and-something-year-old document. Okay, let's see. All right, that's what Madison wanted. Okay, case closed. But they're actually bringing their own experience and their knowledge of what's going on in the world and in the country right now, and they're shaping their decisions based on that. A strict construction would say, I want just a very narrow interpretation of the Constitution. And if it says, for instance, Congress shall make no law, that sounds like it means make no law to me. So I'm definitely a strict constructionist when it comes to phrases like that. Unfortunately, there are many times when the Constitution simply doesn't have a handy-dandy make no law phrase. And so you got to say between the lines, well, what would they have done? What should we do now? We can't call them up or get on TikTok with them. They're gone. We got to figure out something on our own. Loose construction says that, yeah, we always ought to obey, we ought to respect the Constitution. We ought to respect the expertise of the people who built the Constitution. But they didn't think it was perfect. If you go back and read some of the letters and speeches of people like Franklin, like Madison, like Jefferson, Adams, they didn't think it was perfect. They knew it wasn't. There is no human document that's perfect, that's all-seeing and omniscient. They thought they'd given us a darn good start, but there'd be a lot that had to be done down the road, and it's our job to do it. It's also known as the living Constitution. The Constitution is not simply a set of papers under glass somewhere in a building. It's a living document that changes and grows. And then there's originalism, the idea that you really need to look into the language of the Constitution. What did these phrases mean at the time? What did people, late Justice Scalia was a big believer in originalism, is that you have to find something they were talking about. Otherwise, you're just kind of making it up on your own. Well, I got to say, after years and years of watching the court, there's a lot of hypocrisy involved in people who say, I just want them to stick straight to the Constitution. Well, yeah, we tend to love it when we stick to the Constitution and when it goes our way. If it doesn't, we say, wait a minute, why is that still in there? You got to be kidding. We need to change that. So it's kind of flexible. You know, if the other side's winning, they need to stick to the Constitution. If you're winning, there's nothing wrong with changing up some ideas of things. I'll give you a good example of something that the founders in all their wisdom could never have known about. Some years ago in upstate New York, there was a fertility clinic lab situation where people were storing embryos and eggs for later use. And there were some awful power failures in a storm, and the backup generators failed too, and many of the embryos died, were no longer viable. Well, needless to say, there were lots of lawsuits stemming from that. So you ask yourself, all right, the original founders or the first people who were on the Supreme Court, what would they think about the storage of embryos? What would they think about storage facilities, power failing? What would they think about electricity? You just can't always look for a literal analog to what the founders were thinking. That's going to require some interpretation. If judges didn't do that, if they couldn't do that, then when those cases came before the courts would just say, nothing we can do about it, sorry. And so you'd have a valuable loss of life and or property for which the law has no remedy because it wasn't mentioned 200 and something years ago. That's not going to be a workable situation. Now, the judges argue about a whole lot of things, but I've tried to distill out a few of the constitutional issues that come up a lot in Supreme Court arguments over the decades. These are in the Constitution and the Bill of Rights, and they often are at the center of certain cases. So, for instance, the Commerce Clause, which says the Congress shall have the power, quote, to regulate commerce with foreign nations and among the several states and with the Indian tribes. Well, when you get to that phrase, power to regulate commerce with foreign nations, does that sound like a tariff? And this is why, even though it took a long time, and we'll get to this decision later, from the very beginning of the tariffs in Trump's second term, people have said, wait a minute, wasn't Congress supposed to have something to do with this? Weren't they supposed to be the ones initiating these tariffs and figuring out how fair they are and all that? Is it just supposed to be one person's desire? Oh, let's see, okay, 12% on you. No, wait, 14 on you, and other one over there, I don't know. How about 18 on you, okay? Is it just supposed to be that sort of arbitrary? Or was Congress supposed to have a role? Well, finally, a few weeks ago, the court came back and said, you know what? Excuse me. Congress is supposed to open up its doors and do something about this. It's not supposed to be a one-person solo operation to levy these billions of dollars worth of tariffs on other countries. And so at that point, the court sort of woke up and said, you know what, if Mr. President, kind of move back in your lane there, okay? There's other parts of the government here. Remember, there were 3 equal parts, not just one. The Supremacy Clause basically says federal law trumps, no pun intended, state law. And that when they come into conflict with each other, with very rare exceptions, the federal law rules. Supreme law of the land, and the judges in every state shall be bound thereby, said the founders. The Establishment Clause, this is something that's been in the news quite a bit lately, as you have various groups who believe that the country needs more religious influence in the schools, for instance. And this says, Congress shall make no law respecting an establishment of religion. Now, what that means is there can be no state church. There is not supposed to be a state church, not now, not ever. There is not supposed to be a favored religious group. That the biggest, most powerful church in the country is supposed to have no more favoritism from the government than a lone atheist living outside of Waco, Texas. It's all supposed to be equal. And so the government is never supposed to put its finger on the scale and say, you know what, I know but we like this religion more. It's just not supposed to happen. We got several cases about that coming up in a few minutes. Now, the search and seizure clause of the Fourth Amendment, this is really interesting because this was written, the Fourth Amendment, of course, was written in a time when everything valuable was basically a physical object. It was something that you could find somewhere in a house or a basement or the back seat of a wagon or something like that. Today, of course, we're in this digital world where a great deal of very valuable property is not tangible. It's not like this Amazon Basics battery here. So the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants from judges shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. And that's just as valuable today as it was in an age of completely physical reality. You cannot simply go to a judge and say, you know what, this guy living down on Cranford Avenue here, I know there's something going on in that place, and we just want to look around for a few hours. Can we do that? No. You're supposed to say, we believe he is guilty of this. We believe on these premises we will find the following things, and we would like permission to go there and go in and see if we can find them. It gets pretty specific. I mean, if you find other things that were not specified in the warrant, those are not supposed to come in. Those are known as the fruit of the poison tree, and they are not supposed to be admissible to a jury. You might want to go back and get another search warrant sometime, and if the guy is so unfortunate as to not have moved the stuff, then you might find it with a separate search warrant, but not on that original one. Okay, a couple of others here. The 14th Amendment is maybe one of the most it might be the most valuable amendment after the First Amendment. And it has three important parts to it. And several of the cases we're going to discuss here in a few minutes all were decided because of what the 14th Amendment says. And among other things, there's what they call the Privileges and Immunities Clause of the 14th Amendment. It says, no state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States. Okay, let me define those for you. Privileges here means things you are entitled to do as a citizen. Immunities means things that cannot be done to you as a citizen. The sort of wall of rights that you have around you in a free society. Anything that runs afoul of those privileges or immunities is going to have a hard time surviving a Supreme Court decision. Also very important is the Due Process Clause, which appears both in the Fifth Amendment and the 14th Amendment. So if it's there twice, you got to assume the founders thought this was pretty important. And it says, nor shall any state deprive any person of life, liberty, or property without due process of law. And that's been an issue, of course, in a number of these deportation cases that have come up over the past year. Aren't some of these people, they argue, their attorneys argue, they are being deprived of liberty for certain, possibly property, without due process of law, meaning they never got a chance to go into court with somebody standing near them who knew something about the law, aka a lawyer, and say, here's why we believe these charges have been wrongly brought. Here's why we believe that the definition of terrorist or illegal alien or whatever does not apply to my client. They haven't had that. They haven't had due process of law. In the end, they may be guilty. In the end, they may deserve removal. But we don't just do it that way. It's not like the old joke about the Western movie, you know. I know he's guilty. Just take him out and hang him. We'll have the trial later. You know, it can't work that way. You got to have the trial first. And that's called due process of law. The Equal Protection Clause is also very important, 14th Amendment. Nor shall any state deny to any person within its jurisdiction the equal protection of the laws. Equal protection of the laws. Remember that phrase because we're going to be using it several times later on here. There has to be equal protection of the law. Otherwise, you end up with an unequal society in which certain laws apply to these folks, but they don't apply to those folks, or vice versa. You may not know this, but for a long time, as I have a note here, the court had held for a long time that basically the states got a free ride on issues of the Bill of Rights. That the Bill of Rights really didn't apply to the states because it had been set up originally as an agreement between the federal government and the citizens. Okay, so not the states. Well, that's not real satisfactory because most people live their lives in states. And if you have protections for your rights on the federal level, but they can be violated on the state level, that where you actually live, that doesn't do you a whole lot of good. So what happened in 1833, the court sort of alerted themselves to this and said, you know what, the Bill of Rights needs to apply to the states too. Otherwise, people are having their rights violated, even no matter what Washington says, they're still being violated in Atlanta or Milwaukee or Chicago. So at that point, the federal government, the First Amendment was extended to the states. Now we have a bunch of questions about the Supreme Court here. Any comment, or just quickly, any comment or question, and we'll definitely have time at the end for more questions. But the Supreme Court was created, as you might expect, in the Constitution, Article 3. The judicial power of the U.S. shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time establish. Inferior there meant lower. It didn't mean they were necessarily not as good. Now, what's the Supreme Court about anyway? I mean, what are its powers? And I could go on for about 30 minutes on its powers, but let me just distill a few of them here, okay? It is the court of last resort for those seeking justice. It is the final stop. As one justice once said, we are the last word not because we are perfect, but because someone has to be the last word. Otherwise, these things go on forever and nobody knows where they stand. So they are the last word. Traditionally, it has always made sure that each branch of the government, all three of them, knows the limit of its powers. It has been sort of the referee in saying Congress does not have the power to do that. The president does not have the power to do that. This lower court does not have the power to do that. They're the ones who finally are supposed to come and say, as it says on the wall of the Supreme Court, it is the duty of the judicial branch to say what the law is. In the end, someone must say, this is the law and that is not. Otherwise, things are in a quagmire forever. It also protects civil rights and liberties by striking down laws that violate the Constitution. It blocks laws that harm unpopular minorities, and that could be minorities of all sorts. It could be minorities having to do with race or religious preference or sexual preference. It could have to do with minorities who simply have unpopular ideas. We're going to see a couple of those cases for sure in a minute. Now, somebody once said, kind of a cynical person once said this, you have to remember that the court is a powerful defender of rights and liberties, except when it is not. So there you go. It's kind of like in baseball, you know, good hitting will beat good pitching every time, except when it doesn't. How do you get on the court? This has become much more publicized than it used to be. Up till about 20, 25 years ago, the whole process of the court was not very well known. It's been more of an obscure branch of the three branches. Everybody knows the president, and there's so many of the members of Congress that almost everyone knows something about them. But the court, especially since it still to this day is not televised, is just a little more mysterious. But you get on by being nominated by the president, confirmed by a vote of the Senate. It used to take 60 votes to confirm somebody, and now it takes a bare majority of 51. So a couple of things that we might say spinning off of that. It might have been better back when it required 60, because if you think about it, if you know you have to get 60 of the 100 senators to vote with you, you might think, if we put this person up as our nominee, they're never going to get 60 votes. So that's going to fail. So we maybe need somebody who's a little more amenable to both sides. Well, when you're down to 51, if you have 51 votes, you're in. So you might be thinking back on that list of justices on the first page there, Clarence Thomas is now 77 years old. I don't think it's out of the realm of possibility that while the Republicans still have control of the Senate with 57 votes, that he might retire voluntarily so they could put somebody 30 or 40 years younger on the court who would be just as conservative but would be there well into the century. I've not seen that rumored even, but I don't think it's beyond the realm of possibility. I don't know about his health, for instance, but he is 77 years old, and it seems unlikely that the Democrats can win 7 Senate votes in the midterm elections. Not out of the question, but unlikely. But that might be their thinking somewhere. Back when the Democrats still had the majority in the Senate, some people were saying that maybe Justice Sotomayor ought to retire. I mean, she's 70, she has diabetes, she may be coping with it perfectly well. But in other words, the idea being, while we've got the chance, let's put somebody on who's about 42, 43 years old, and thank you for serving. But she did not want to do that, so that was it. What does the Constitution say about the qualifications of justices? Well, as you might expect in a document this short, there's places where there's just not a whole lot of detail. And this is one of them. There's no requirement about age. There's no requirement to be born in America. You don't have to be a lawyer or a judge. Now, and if you stop and think about it, that may seem kind of odd, but when this document was written, there were really almost none of what we would call law schools today. Weren't really even a whole lot of universities of any kind around. So what most people learned the law through was an apprenticeship. They would get together with a judge and for some minimal salary perhaps and learn the law from that judge. Now, as it turns out, almost everyone who's been on the Supreme Court, everyone actually, has either been a lawyer or a judge, but there's no requirement to be. So if tomorrow a president wanted to nominate and the Senate wanted to confirm somebody who had no legal training at all, they could. There's nothing in the Constitution that blocks it, except maybe common sense, but I don't know where that clause is in the Constitution. The common sense clause. How about the size of the court? It's been at 9 for quite a while, but in its history, it has been as few as 5 justices and as many as 10. It's up to Congress, not the court. The court cannot enlarge or shrink itself. It is beholden to Congress on this. But if the Congress wanted to change it to 13 justices or 17 or 7 next week, they could. Just a majority vote. I don't know who'd have to get off the court if they went down to 7, but maybe first hired, last fired, or something like that. First fired, yeah, okay. It was set at 9 around the time of the Civil War, and it has remained there ever since. Now, some think, every time we have a battle over a Supreme Court nomination, and they're all battles now. What's that one battle after another, that movie that's out now? Is that about the Supreme Court? I don't know. Every time there's one of these apocalyptic battles over putting somebody on the court, certain legal experts will say, you know what? If we had a lot more justices, each one wouldn't be so unbelievably important. Well, if you had 14 or 15 or 17, then every time you lose one, it might not change the balance the way it does now. And there have been certain legal scholars who have argued that you ought to try an even number, maybe 10 or 12 or something. Now we say, wait a minute, isn't that going to result in a lot of tie votes and a lot of wasted time? Well, maybe. But it also might make them work harder for compromise decisions that they know they can get a majority on, because they're going to have to pick up somebody on the other side, at least, to win 6-4. As for whether those reforms ever might take place or not, I don't know, but they're all within the power of Congress to do that if they wanted to. Why do they serve for life, and why also can their salaries not be lowered during their term? That is for independence, judicial independence. And if you want to see what happens when you don't have that system, look at Texas. Remember a few years ago, Ken Paxton, the Attorney General, now the Senate runoff person, who says he's not dropping out. He does not care what anyone says. He's not dropping out. Remember, he got angry with a number of judges who didn't go his way on some things, and he campaigned against them and got 3 or 4 of them unelected, got them voted out. You can do that in a place like Texas, where you elect these judges for these fixed terms. In the Supreme Court level, you simply can't do that. You can bluster if you want to, but they don't really have to listen to bluster. So that's independence, just simply to isolate them from political pressure. Our system in Texas, as we just all proved last week when we went and looked at the names of 44 judges that we had really never heard of. We didn't want to tell anyone we didn't know about them, but they had the right letter on their name, so okay. Everybody knows the Dallas County Courthouse has turned over party membership about 5 times since the 80s. In the 80s, it was solid Republican. And then as the county begins to shift more Democratic, then a lot of these judges who don't care at all about political party, they jumped over to the other party just to keep getting elected. It's kind of a weird system, but that's Texas for you. The longest serving was William O. Douglas. Now, you want to picture the span he was on the court? He was nominated during Franklin Roosevelt's second term in 1939. He was still on the bench when Richard Nixon was driven out by Watergate in 1975. How the world changed during that time. A Supreme Court justice can be a president's longest lasting legacy. I mean, FDR was long gone by the time that Douglas went off the court in 1975. Now, back to Clarence Thomas for a minute. He has now served almost 35 years, so he's close to breaking Douglas's record. And whether that matters to him, I don't know. I've never seen a statement on it. But that might be one thing he might want to hang on to the court at least that long. So who knows? But now, how about this? Imagine this today. Do you have to nominate a justice from your own party? The answer is no. There is nothing in the Constitution that says that you have to get, if you're a Democrat, you got to get a D, and if you're a Republican, you got to get an R. There's nothing. Has anyone ever dared to do that? Well, yes. Eisenhower, Republican, nominated William Brennan to the court in 1956, thinking he would be a good judge for the country. He would serve the law. Brennan turned out to be very liberal, and Eisenhower spent the next 15 years kicking himself that he had put, not that Eisenhower was a stone-cold right-winger, but he was, a moderate conservative, and he quickly saw that Brennan was not voting as he might have wanted on a lot of issues. On the other party, on the other foot, Harry Truman appointed a Republican named Harold Burton to the court in 1945. If you want to make a list of things that would never happen today, you want to put that on the top of your list. They were never going to give a nominee to the other party today. That's the last thing. They would pull teeth with pliers before they would do that. But that was a different time in which, you might have said to somebody, I disagree with some of his votes, but I think he's a good person. I know he'll honor the Constitution, so I'm going to nominate. Who put the most justices on the court? Well, the easy answer, and that you might think about, would be the first person who got to put any on the court, and that, of course, would be George Washington. He served 2 terms, and he got to put 11 in his 8 years. Some went off the court, and he replaced them. Franklin Roosevelt was around a long time. He was president almost 14 years, almost 4 full terms. He got to nominate 9. So the entire court, by the time he was finished, were his nominees. Now, here's one you might not have thought of. William Howard Taft, who had one of the largest mustaches of any president ever. I think it's in the Smithsonian. He only served 4 years as president. He got to appoint 6. It just shows you sometimes, when he came to the presidency, there was an inordinate number of really old folks on the court. As he privately said, you got a bunch of old fools who've hung on too long. And he was quick to replace them when he could. So he got 6 in 4 years. Now we flip the question over. Who never got to nominate? Never got to nominate a single justice. Well, you know the answer of one of these, and I'll tell you in a moment why you know this, okay? But the others you don't know. William Henry Harrison died a month after becoming president and never had a chance to do anything, sadly, except lie in the White House and die. Zachary Taylor never got any. Andrew Johnson, Lincoln's successor, never got any. And of course, the always unlucky Jimmy Carter. He was unlucky with the hostages, he was unlucky with the energy crisis, and he never got a chance to nominate a Supreme Court justice because there weren't any openings. So you could always say there was no justice for Carter, okay? No justice. Now, a rare distinction in American government, William Howard Taft became a Supreme Court justice, which was what he really always wanted to do. He had been a judge before becoming president, and his mentor, Teddy Roosevelt, kept saying, you're going to go on the Supreme Court eventually, but we need you to do some other things first. So first he went and he was governor of the Philippines for a while, and then he was Secretary of Commerce for a while. But they always said, you're going to get on the court. Don't worry. He really didn't like being president much. He didn't like a lot of what went on with the presidency. He liked Washington quite a bit. He loved Washington society and parties and that sort of thing. But what he really wanted to do was be on the Supreme Court. So finally, he got on the court. He was Chief Justice. To show you how much he loved Washington, there's only 2 presidents buried at Arlington National Cemetery. You know one of them, of course. And on any given day, if you go to Arlington, even if there's a cold, drizzly rain, you will see a big crowd of people at John F. Kennedy's grave. But you're going to have to ask to find Taft, and there may not be many people when you get there. But by the way, all the presidents have been eligible for burial at Arlington since it was created. But only 2 have chosen to be buried there and not in their home state. So Kennedy and Taft. Yes, this is really true. A U.S. senator once said, why can't we have mediocre people on the Supreme Court? What had happened was Roman Hruska was a Republican senator from Nebraska, and he had watched President Nixon put 2 nominees up for the court, and both of them were rejected by the Senate. And a word that popped up a lot was they're just mediocre. They're not distinguished jurists. They haven't said or done or published anything that would make you think they know much about the law. So we're not going to put them on the court. At that point, Hruska on the Senate floor kind of blew up, and he makes this long speech. He says, you know what? We got mediocre dentists. We got mediocre carpenters. We've got mediocre plumbers. Why can't there be some mediocre justices? There's a lot of mediocre people in this country, Don't they deserve any representation? So that is true. He did say that. The first black justice was Thurgood Marshall. He had a pretty distinguished career before getting on the court. He had been the lead lawyer for the NAACP. He argued the Supreme Court case of Brown v. Board of Education that desegregated the schools. And he, LBJ appointed him, put him on the court in 1967, and he served for 25 years until he was replaced by Clarence Thomas. The first Jewish justice was Louis Brandeis. Brandeis University is named after. He was a progressive lawyer named by Woodrow Wilson to the court. He was thought of as brilliant. But he was also in a time when open anti-Semitism was pretty much a thing in America. I mean, you could, as an elected official, you could make anti-Semitic remarks and pay almost no price for it. And so many people were just shocked that they would put a Jew on the Supreme Court, and others were even more mad about his politics. They said here's some of the reaction. The New York Times called him a radical. Former President Taft said that his nomination was an evil and a disgrace. And 6 former presidents of the American Bar Association said also opposed him. Well, here's the historical footnote on this. The uproar against Brandeis and some swelling of opinion for him was so much that the Senate decided for the very first time it would have a hearing. And this is what led to the tradition today of having these hearings and having where you get witness from both sides. You get people who think this is an excellent lawyer, you think he was a horrible lawyer. You get character witnesses. You bring all this together, and then you decide whether you want to approve this nomination or not. Well, this all started with Brandeis. So he did get confirmed to the court, and he served for 23 years. And when he retired, the New York Times had changed its editorial mind, and it called him one of the great justices of our time. But that was a time when being a public figure, a Jewish person as a public figure, people could pretty well slam you for being Jewish, and that was the way it went. Sandra Day O'Connor, the first female appointed by Reagan, 1981. She had earned a law degree from Stanford with honors, but being a woman in that time, she got no job offers from any large firm that she applied to. So instead, she kind of went at it another way. She got a job as an assistant city attorney. Then she became the assistant attorney general of Arizona, and then a state senator, and then got on the Court of Appeals. And then Reagan wanted to put the first woman on the court, and so he chose her. On the court, she was what you used to call a swing voter, meaning she could go either way. She was not a predictable vote on issues like abortion rights, like voting rights, but more of she could go back and forth, kind of the middle vote there. Okay, so what does the court do all day anyway? I mean, well, they review cases, and then they write decisions, and then they announce them. There's a lot of people that want their case in front of the Supreme Court. In a typical year, about 7,000 cases are sent to the Supreme Court for them to decide, do we take this case or do we not? Now, the vast majority are turned down. In fact, the most common thing to happen to a Supreme Court case is for it to be turned down, is for the court to say, we don't want to hear it. In a typical year, they take about 70 to 80 that they're really going to thoroughly look into and make a decision on. The others, the court looks at and says, keep in mind that before anything gets to the Supreme Court, there's 2 levels, at least 2 levels, judicial levels below that have already looked at the case. There's a trial level, usually a district judge or federal judge on the trial level. Then there's an appeals court level, and then if it goes further, it goes to the Supreme Court. At that point, the court has to say, do we think the lower courts got anything wrong? And in the vast majority of cases, they say, no. We think the court got it right. And so there's nothing we can add to it, so we are declining that case. And that's the end of it. If the court declines your case, the previous decision stands. So, by the way, back up to 1925, the court was supposed to review every single case sent to it, and which just proved to be overwhelming. I mean, 17 judges couldn't have handled all that. So they went to Congress, which controls this, and they said, we need to be able to reject more of these cases. And so they did. Now, you probably think, okay, I want to say just a little more about this, because sometimes people will be surprised to learn just how a case gets decided at the Supreme Court level. So here's a couple things. There are 2 types of filings that need to be done first before the court just considers it and makes its decision. First, once they say we are taking a case, we are granting certiorari, as we'll talk about in a minute. When they say we are taking this case, the first thing that happens is the two sides send written briefs about the case. And also what are called friend of the court briefs. Anybody who has some kind of professional or legal standing that wants to weigh in on this can also send a brief. These are called friend of the court briefs. For instance, on any abortion case, there will be dozens, if not hundreds, of friend of the court briefs from every medical association involved, from people who've worked with counseling abortion clients, both for and against, with universities that have some expertise in this. And all they're doing is hoping to influence the justices in their final decision. So that's the written brief part. Then, a few months later, they schedule what they call oral arguments. Now, at this point, what happens is, you may be surprised to learn, each side gets maybe an hour, hour and a half to present their case. Now you think, wait a minute, I couldn't even read it in an hour and a half. But you got to keep something in mind. Those other two levels that I talked about a moment ago, the appeals level and the trial court level, those have already dealt with a ton of the details and the machinery of the case. That does not get replayed in front of the justices. If there were witnesses at the trial level that saw Smith and Jones meeting at the hotel at 1 o'clock, that's in the trial testimony record. That's not, Smith and Jones don't get to come to Washington on a free trip and testify in front of the judges all again. That would take forever. So what happens is the judges, when it comes to oral arguments, the justices are very focused. Suppose that the case they're looking at had 4 parts dealt with by the lower courts. They might look at that and say, we have no problem at all with what the court did with 1, 2, and 3. But when you get to part 4, we think the court may have made a mistake here, and we want to hear more of it. So they direct each side to focus on that 4th part. Not 1, not 2, not 3. We've heard all that. We've read it. Our law clerks have read it. Tell us about 4. So that's how it can be manageable in an hour and a half or so. Plus, most of the people who argue in front of the court, like the U.S. Solicitor General who presents the government's case in front of the court, most of them have been around this block a lot of times. And they know how much the justices want to hear. And they can sometimes tell if somebody's been sitting here like this, and all of a sudden they go, this. And it's like, okay, he's heard enough. Get off that point. he's getting irritated. Don't say that again. So they know the court pretty well. All right, so that's kind of how that works. And that's how come even the 70 or 80 they take can end up in decisions that might be 80, 150 pages long, with footnotes from here to Albuquerque. Now, if we're talking about the Supreme Court, we have to have some Latin, right? Okay, so if you remember your Latin, great, I don't. But the 2 terms we are going to talk about are certiorari. When the court grants certiorari, that means we're taking the case. And the Latin means to make more certain, certiorari. It also sounds like a drink you could order in an expensive nightclub. I'll have a certiorari on the rocks with just a twist of lime, please. Can I get that? So they want to make more certain. So that's what they're going to focus on here. It takes 4 justices to grant certiorari, or cert, as it's sometimes called, so they can make more certain that the lower court got it right. The stare decisis is another Latin term we have to know. That means to stand by earlier decisions, to respect the precedent that was set when the court did this decision 40, 50 years ago. For instance, Roe v. Wade had a 50-year precedent when it was thrown out. It had been around, 50 years is a good chunk of the nation's history. So it had been around for about 50 years when it was abandoned. And you may remember that all 3 of Trump's nominees for the court, Kavanaugh, Gorsuch, and Barrett, all said really nice things about respecting precedent and stare decisis when they were having their hearings in front of the Senate. And then they kind of went the other way on that, and maybe going the other way on some others we're going to talk about in just a moment. Now, this doesn't mean the court can never change its mind. I mean, the court has made some bad decisions in the past, and it's good when it revisits them and says, you know what, that was just a bad decision. We're not perfect, we're not angels. But if you have too much of that, it undermines people's faith in the process. Oh, wait a minute, 2 years ago they said it was fine, now they say it's not. 6 years ago they say it's not, oh, now they say it is again. That undermines faith in the law, it undermines the citizens' belief in it, and it doesn't send any clear message to the lower courts. The one thing that a Supreme Court decision does is send a clear message to the lower courts. Don't send us anything more like this now, because if you do, you're wasting your time. We're going to reject it. We've dealt with this. Unless new people come on the court, there's no point in hammering on this door anymore. So at that point, the law community and the lower courts have some guidance. They say the Supreme Court has already ruled on this, and we are not allowing you to testify on that now. Sorry. All right. Now, the 5-4 decisions, the big hot button cultural war issues, are the ones that most people are most aware of. So, given the headlines, you might think that in a given year, almost all the important stuff is 5-4, closely divided. But really, it isn't. Of all the possibilities, unanimous, 8-1, 7-2, 6-3, 5-4, of all the possibilities, in any given court term, there are more unanimous decisions than there are 5-4 decisions. In 2023, for instance, in that court term, there were 14 5-4 decisions and 27 unanimous decisions. So they agree more often than they disagree. The reason the public doesn't see that is because a lot of the unanimous decisions are not very controversial. They don't get a lot of headlines. They might have to do with a water rights dispute between Arizona and New Mexico, for instance. Well, that's important there, but most people around the country are not going to be very aware of that case, and so they're not going to care much about the result. Now, you probably have gathered this. Since Trump put those 3 nominees on the court, there are more closely divided 5-4 decisions than there used to be, and especially a lot more 6-3 conservative v. liberal justices than was the case. But still, the judges find a lot of reasons for unanimity. There was a big case a couple of terms ago, I think from Arizona, where police had stopped people and taken their cell phones and gone through their records and all and copied some of them and everything without any kind of warrant. Apparently thinking that since the Constitution doesn't mention cell phones, it must be okay. And the court unanimously said, no, that is not okay. Most people carry huge parts of their lives on those phones, right? Am I right? Right? And don't lose it. And we're not letting you just breeze into their lives and take this stuff without a court order. All right, so the Marbury v. Madison case was important. I don't want to bog into the details on it, which has to do with people not getting their commissions for judgeships that they were given, and they thought that they were going to be judges, but then the term expired and they didn't get their judgeships, and one of them sued. Okay, I know. Enough. But what happened, the upshot was this. This was the first case in which the Supreme Court really exerted its authority to make itself equal to the legislative and executive branch by saying the Congress has passed a law here that is unconstitutional, and we are saying it's unconstitutional and it cannot stand. And they put people but at that point, the court didn't even have its own headquarters. It was kind of in a basement of some other building somewhere. But this decision really said, we have our space too in this 3-part government, and we have a role we can play that you cannot play. And we can tell you that we don't think your law is in line with the Constitution, and if so, we're going to declare it unconstitutional. That was really revolutionary at the time. It's fairly common now, but not then. Let's see. These 4 decisions here in the cases of, let's see. Yeah, Scott v. Sanford, Plessy v. Ferguson, Buck v. Bell, and Korematsu v. United States. What do they have in common? they are generally considered by scholars and historians of the court to be the worst decisions the court ever made. Talk about getting it wrong. Let me briefly discuss each one. Scott v. Sanford had to do with a slave that had gone into free territory and thus believed that he and his lawyer believed he was then a free citizen. And so they sued in court, and Dred Scott was the slave's name. And shockingly, the court ruled that not only could he not win the case, he shouldn't even be in court at all. He was not a U.S. citizen. He could never be a citizen because he was property, and therefore shouldn't even be taking up their time at all. So he was still a slave. But having done that damage, the court then went a big step further. At the time, there was something called the Missouri Compromise that Congress had passed in an effort to sort of somehow limit the spread of slavery. So the deal was one state would be admitted as a free state, another as a slave state, and on and on. The court, though no one had asked them to do this or look at it at all, just said, oh, by the way, the Missouri Compromise is unconstitutional. Congress cannot regulate slavery this way. Well, at that point, a lot of people who've been working to avoid war on this issue sort of threw up their hands and said, if the Congress has no power to slow down the spread of slavery or reverse it, what is there but war? So this is one of the few Supreme Court cases where you could actually say this probably moved the country closer to civil war than it had been before. Few cases are that consequential, because if law doesn't work, the only thing left is force. Hang on a second. Plessy v. Ferguson was the separate but equal case. In this case, school districts in the South had sued, saying that the white people have much better schools, they have better teachers, the teachers make more money, their facilities are better, our textbooks are 20 years out of date. And the court said, nothing wrong with that. As long as as long as the schools are substantially equal, just go right ahead with desegregated schools. And that was the law of the land for the next 50-something years until the Brown v. Board decision came along and said, separation is inherently unequal. There's never been any claim that the black schools in the South were equal in any way to the white schools. This has been 50 years in which people were kept in a state of a miserable state of very inferior education, and it's got to stop. So there was that case. Buck v. Bell established that it was constitutionally okay to sterilize mentally handicapped people even against their will, to stop the spread of this of idiocy, as it was called at the time. And finally, the Korematsu decision was just a stunning failure of democracy. This is where, in World War I, thousands and thousands of Japanese American citizens were moved into what you might as well call concentration camps, for the crime of being Japanese American and therefore suspect in their loyalties. This was a triple failure of democracy. First, Franklin Roosevelt issued an executive order, there's one of those again, saying they need to be put in these camps. The Congress then followed by approving that and giving it the stamp of law. And when it was appealed to the Supreme Court said, no, we think the president got it right, no problem. So all three branches of democracy failed and put these folks in there for years of their lives. Later, that's one of the few decisions that the court has ever apologized for later on. What about religion? Okay, we've got the Ten Commandments being tacked up on walls in the schools, or some schools at least. Some are saying they're not going along with it. We've been here before. There was a case called Stone v. Graham back in 1980, where it was a case out of Georgia, and what happened was they passed a law that saying the Ten Commandments must be put on the walls of our schools, and to sort of thinking that they were getting around the problem, instead of having the schools pay for it or the state pay for the signs, they got local business people to philanthropically donate money for the signs. Well, the Supreme Court said, well, that's a nice try, but that doesn't work. You're still not getting around, you're not dealing with the problem. The problem is compulsory education. Children have to go to these buildings every day. Regardless of what they are taught at home about religion, they are now being presented with the religious beliefs of a certain part of Christianity. And then the argument then, and the same argument will come up now, the argument was, oh, wait a minute. There's a lot of good wisdom in the Ten Commandments that has nothing to do with religion. Honor thy father and thy mother, thou shalt not kill. But the problem is it starts out with advice that is important to those who worship in this particular religious branch. Honor the Sabbath, keep it holy. Thou shalt have no God before me. That sort of thing. So if you're a Hindu kid or a Jewish kid and you're sitting there looking at that, you're basically in a place where you have to be. Adults don't have to go anywhere at a certain time of each day, but kids do under compulsory education. So the idea is then that here are these kids who are malleable, who are easily influenced, and they are being shown these religious ideas. Now, the court has gone back and forth on that, though. That was a 1980 decision. In 2005, there was a case called Van Orden v. Perry, that would be former Governor Rick Perry of Texas, in which a group wanted to put a big statue of the Ten Commandments on the Texas Capitol grounds. Well, if you've been to the Capitol grounds, it's like there's almost a statue for anything you can imagine there. I mean, there's like 19 different statues and monuments to, for all I know, praising the crawfish caught in the Gulf or something. I don't know. But and so at that point, the court said, "No, wait a minute. You got to see the Ten Commandments as both a religious symbol, yes, but also a historical symbol, a symbol of what Texas has been important in the development of Texas. And it deserves at least a place out there with 18 or 19 others, other monuments and testaments of belief. And so they okayed it. Now, this is going through the courts again. Just the other day, a similar law to the Texas law in Louisiana was given a temporary okay in Louisiana by a court of appeals, and that then will be kicked up to the Supreme Court too. So probably this summer, probably in June, we'll get a decision on that, and it'll be interesting to see which of its precedents the court follows. The one where they said, no, you can't put these in the wall, or the one where they said, yes, you can put them in the Capitol. So we'll see. The Shadow Docket. Sounds like a band name. Ladies and gentlemen, the Shadow Docket. Let's bring them on. Come on. Now, the Shadow Docket has gotten out of the shadows over the last year or so. The Shadow Docket was normally used. You have the written public docket. A docket is a list of cases that are going to be taken up. So you have the shadow docket is for emergencies, for odd things that come up just once in a while. For instance, suppose the court is out of sessions. They're taking their summer recess from June to October. And an execution comes up in a certain state, and the person is supposed to die at midnight, and the lawyers claim they have some new things that they believe were not really considered carefully enough, and then they want an appeal. Well, what happens is the justices divide the country into territorial districts, and so whichever justice is abiding over that, they call that justice and say, hey, we need a stay of this execution. We need it now. And the justice does a little thinking about it, maybe a little consulting, and says, okay, we're going to hold this for 1 month for further arguments in the court. Well, that's obviously got to be dealt with right then. You can't say, well, we're on vacation and we'll be back in October. You think he can hang on that long? Well, no, he's going to be executed like tonight. So it makes sense that there would be something that could be done rather than wait till the court comes back into full session in October. The problem is, and there's a few other things analogous to that, the problem is over the last year or two, the shadow docket has been used more and more for really important matters that ought to get full deliberation by the court, that ought to get what we talked about a minute ago, submitting written briefs, having oral arguments. That takes a while, yes, But what several of the justices have complained about, and it's pretty unusual to see them complain openly, some of the justices have said the more important these cases are, the more consequential they are, the more we need to be deliberating and telling the public, showing our work, telling the public why we're doing this instead of simply, no, we do not agree. I mean, these can be like 1 or 2 sentences. Yes, this can continue. That's it. Why? Who wanted it? Who didn't? So it doesn't inform. It's not, the word today we use so much about government is transparent. It's not transparent at all why this shadow docket is being used so much. And just on a partisan basis, a number of the shadow docket decisions over the past year have favored Donald Trump and activities that he wanted to continue doing. And essentially the court has said, you go ahead, and at some point there'll be a full hearing of this, and then we'll deal with it then. But in the meantime, you go ahead. That's what happened with the tariffs, and it took almost a year to get the decision on it. The law is a lot of things, but the law is rarely fast. And the law cannot possibly act with the speed of one individual in the executive department. All right. So, just 1 second, please. All right. Now we have some individual cases to look at in the past and recent present of the court. Bush v. Gore, you remember, was the 2000 deadlock over the election, which just is still stunning to think that many votes were cast and it came down to that few in one state. And what happened was, you remember the dimple Chads? Remember those? Remember the hanging Chads? Remember the guy named Chad who was, remember that there was a cover of Newsweek, back when Newsweek used to be important, that showed some guy with a magnifying glass, and he's trying to figure out if this is a dimple Chad or a hanging Chad. And so, and what happened then was different counties began making different decisions. So this county over here would say, all right, the dimple Chad, yeah, that's in. Yeah, you can tell the voter wanted to do that, but just didn't get all the way through. And the other county a few miles away would say, no, wait a minute. Unless it's all the way through and perforated, that's not a vote. So they would toss that out. Well, can anybody say 14th Amendment? And that's what eventually the Bush people sued under. They said, this violates the 14th Amendment Equal Protection Clause. The people here are having their vote denied for doing one thing. The people over here are having their vote accepted for doing basically the same thing, but not quite as much. So they said that's not a standard. You can remember the Gore people wanted the entire state recounted, not just a few counties. And at that point, the Florida Supreme Court came in and said, yeah, let's issue a recount for the whole state, just see what's going on here. And at that point, the Bush people went to the Supreme Court, pled the 14th Amendment, and the court ruled in favor of Bush. Now, unfortunately, the breakdown of the vote was along party lines. All the Republicans voted for Bush and all the Democrats voted against Bush. So that left a sour taste in a lot of people's mouths. That's still there today. All right. The Oberfeld decision, there was the, 25. They justified it this way. And let me see if I can telescope this. The Supreme Court at the time that Roe v. Wade became law looked at, they knew that there was no explicit mention of privacy in the Constitution. It's just not there. But they said, it's clear that the founders valued privacy, valued individual privacy, believed that there should be a certain zone around the individual that's theirs to decide on and not the government's. Well, for instance, and they began looking at different amendments. The First Amendment, thou shalt make no law regarding, freedom of speech. So there's a zone of privacy there. They looked at the Second Amendment, which guarantees some right to firearms. They looked at the Fourth Amendment, which keeps you safe in your possessions unless there's a court order to search your place. So they said there's a history of valuing privacy here, even though it's not explicitly mentioned in the Constitution. And there was a previous case called Griswold v. Connecticut that had to do with birth control being outlawed, selling birth control devices. And the court had gone against that because they said, what is more personal and private than the decision of whether to give birth or not? So at that point, the court said, we believe that the Constitution guarantees a right of privacy, and that was used as the main rationale for Roe v. Wade, is that there's got to be something that the government cannot reach into your life and do, and we believe it is to dictate the size of your family or whether or not you're going to be a mother. So, long story short, when the new court came along a few years ago and overturned that, they disagreed with the whole basis of Roe v. Wade. They said there is no right to privacy like that in the Constitution, and since there isn't, the reasoning behind Roe v. Wade was flawed from the start. And that's what one of the justices said. It was wrongly decided 50 years ago, and we have a different decision today. So there went that long-time precedent. The Obergefell Hodges was, of course, the right for same-sex couples to marry. We don't have time for it today, but if you ever are interested in listening to two justices disagree with each other, just go on Wikipedia or Google and find what Justice Roberts said, who was against the Obergefell decision, versus what Justice White said, who was for it. They're really, if you find a summation of their arguments, they're really good. In essence, Roberts says, this is something we shouldn't even be touching. See, he gave the old argument I started with, that if it's not in the Constitution, what right do we have to say what the law ought to be? We're 9 unelected lawyers. We're not doctors. We're not counselors. We're not maternity ward doctors. What do we know about this? So his idea was, let's just stay out of it. And the other side said, based it on the arguments about privacy that I talked about a moment ago. Let's see. The stolen seat, of course, you remember, Justice Scalia died in Texas. Don't blame us. Okay, it just happened to be in Texas. Barely in Texas. Come on, it's way out in West Texas. So he died on a hunting trip, and suddenly there's this open seat. Well, Obama, as was his right, nominated Merrick Garland to replace Scalia on the court. And at that point, Mitch McConnell, the powerful Senate leader at the time, Republican, simply said, I don't care who you nominate. We're not voting on any of them. And proceeded to just stick it in his back pocket and say, no, there'll be no hearing at all. And just, even though at that point, he said, we're too close to a presidential election. The election was 264 days away at that point. So they just stalled. And then sort of the rest of the story, as they say, when Amy Coney Barrett was nominated near the next presidential election, McConnell said they needed to hurry and confirm her because we're getting close to this election. Whether you're a Democrat, Republican, independent, or non-caring, you can't see that as this did not have to do with the law. It had to do with power and how to hold it and seize it and use it. And McConnell was really, really good at that. You have to hand it to him, I think. Now, you say, well, what can we do to stop this from happening again? Well, I actually have a solution if you'll promise to vote for me next time. Okay, in that box back there, I want them in that box, okay? Here's what you could do. Congress could pass a law, or if we wanted to take longer, we could have a constitutional amendment saying that once there is a vacancy on the court, and the president makes a nomination, there must be a full Senate hearing within X days. Within, if you want 1 month, 2 months, 3 months, give everybody time to get ready, give everybody time to prep on it and call their witnesses and all, but there has to be a deadline. And you have to say, by that date, there must be a hearing for this nominee. Vote against the nominee if you want to, but you're going to have to hear both sides and take a vote. That would do it. That would do it. And I don't know, well, I do know why they haven't done it, because they're not going to agree on anything like that. But the problem right now is, once again, as we began by saying, the Constitution doesn't have a great deal to say about the intricacies of the court. So there's still things we're discovering. Oh, you mean they don't have to have a hearing at any given time? Oh, they just always done it in the past because that was the tradition. If someone wants to tear up the tradition, like McConnell, they do. And there's not much we can do about it except the remedy I just proposed. So vote for me. Yes, yes, the court has protected a right to animal sacrifice. This is one of the most interesting cases. I know I'm running on just a little bit here, but we're going to wrap this up soon. Don't leave. There was a case in 1993 called the Church of Lukema Babalua versus Hialeah, Florida. Now, this church, small church, was moving to Hialeah. And they practiced this religion known as Santeria. Some people call it voodoo, but that's kind of a slang name. And it sometimes required the sacrifice of small animals as part of a religious ceremony. Well, this freaked out the city leaders of that Florida town, and they quickly passed an ordinance against it. You cannot do that here. You can still hunt, if you want to, and bring back squirrels and porcupines or whatever. You can still have a butcher shop down at Tom Thumb or Kroger, but you cannot use animals as part of a religious ceremony in our town. Well, again, that's just one of those which directly contradicts the Constitution. What it says, that Congress shall make no law respecting an establishment of religion. Here's this establishment of religion called this church, and they're coming to your town, and you know how they practice their religion, so you pass a quick law saying they can't practice their religion. What's interesting about this, on the trial level and at the appeal level and at the Supreme Court level, the judge and justices said this: this is not about whether you, Mr. and Mrs. Juror, would ever do this. This is not about whether you approve of it or think it's a good idea. The question is, are these sincerely held religious tenets of their religious philosophy? If so, the answer is they have a right to do it. It may be distasteful to you, it's distasteful to me. But there are people who might drive by a big, prosperous Catholic church and say, are they in there with that water and wafer and wine stuff? I mean, come on, let's get rid of that. Why do they get to do that? That's stupid. Well, it's not your business, buddy. That's the part of their ritual, not yours. In a pluralistic society, we're supposed to practice tolerance for people who have different beliefs from ours. As long as nobody knocks on my door at 9 o'clock Sunday morning and says, "Here's your wafer," I'm fine. I'm fine with what they do. It's good for them. So this, Justice Kennedy, in writing his decision, said, religious beliefs do not have to be consistent or logical or understandable by others to deserve First Amendment protection. Think about it. What do we need to, anytime you say this is something we do at our Methodist church or our Catholic church or whatever, is everybody supposed to vote on it and see if you can do that or not? Or is it your choice to do that? So that's, I think, one of the most interesting. And whenever people say, you hear a lot of people say today, oh man, the government's just anti-Christian, or they don't like religious people and all that. I always think this is a case where the court bent over backwards for a very small and probably detested minority to protect their religious expression. So to me, that doesn't sound anti-religious to me. Now, Robert Bork never made it to the Supreme Court. He believed, he was an originalist, and in other words, if he couldn't find a line for it in the Constitution, he didn't want anything done about it. And he believed that only political speech was protected by the First Amendment, not speech about family life, not speech about culture or the arts. Just political speech was the only thing that was protected by the First Amendment. And he believed that same-sex couples had no rights under the Constitution at all. And beyond that, it wasn't just the content of what he thought, it was his manner in front of the Senate. And at the time, Ted Kennedy was the chairman of the Judiciary Committee. And he made no apologies for it. He said there is no right to privacy anywhere in the Constitution. If government wants to make laws concerning people's sexual lives, it can. And Kennedy ran kind of a political campaign against him. It was really the first real aggressive campaign run against a Supreme Court nominee. And Kennedy just ran it like he would have run against a political opponent. and said, in Robert Bork's America, you'll have back alley abortions, you'll have fewer rights for black people. In the end, the Senate rejected him, 42-58, mostly along party lines. Then we had the Hill-Thomas hearings, in which things were heard on TV that had never been heard on American TV before. Thomas said that he was being subject to a high-tech lynching on television. Hill said over and over and over again that he had sexually harassed her in not one but two workplaces, and she never wavered in her accusations. She said that Thomas had asked her to go out with him 5 or 10 times, and she had said no, and that he was retaliating against her. This ended up being sort of a he said, she said affair. Joe Biden was the chair of the Senate Judiciary Committee at the time. It was all male, all white committee. There was an odd, if you remember what it looked like, it was an odd kind of power imbalance there between the committee and Anita Hill. So in the end, Thomas was confirmed. A few years later, he wrote a book about his life, and he came off as very, very bitter. And I reviewed the book for the Dallas Morning News, and my take on it was, why wouldn't he be bitter? One of two things happened. He either was lying, and he lied his way onto the court, and every day that he walked in that building, he would know he really didn't belong there, or he really was telling the truth, and he really was subject to a high-tech lynching. So whichever way you go with it, why wouldn't he be bitter? I mean, why would he just be, oh, well, no problem, everything's, we all have our disagreements, don't we? As for recusing yourself, taking yourself out of a decision, there is no rule on the Supreme Court that says you have to do that. Lower courts are subject to rules like that, with conflicts with family members, conflicts with financial matters, that kind of thing. There's no rule like that with the Supreme Court. Some think there ought to be. It's all voluntary. For instance, when Elena Kagan was the Solicitor General of the United States, before going on to the Supreme Court, she had already argued one way or another on a number of cases that eventually came to the court. So when those came to the court, she wisely said, I've already let my opinion and my reasoning be known on this. I'm not going to take part in the decision. I'm out. Which was, again, a wise thing to do to avoid any conflict of interest. Just to say, I'm supposed to be looking at this evidence fresh as a justice, but I've already weighed in on it. How can I be looking at it fresh? So she went out. So you can't make any justice do that. Let's see. You remember the Trump case a couple of years ago, where a couple of states wanted to keep him off the primary ballots. Well, based on what you know now, you probably know that when that went to the Supreme Court, once again, it was found to be a violation of the 14th Amendment of the Equal Protection of the Laws. If this state has Trump on the ballot and the neighboring state does not, somebody is being denied their rights to vote for a candidate they want to vote for. So that decision didn't surprise me. I don't see what else the court could have done. By the way, Congress could, in fact, have intervened and taken people off the ballots, but only Congress can do that. And that's what the court pointed out. You remember the Trump total immunity case. To me, in 30-something years of reading, studying about the Supreme Court, reading decisions, this to me is just one of the most baffling ever. I read the decision 3 times. You ought to read some Supreme Court decisions. They're readable. They're not easy reading. You don't want to read them on the beach or with a couple of martinis, but they're readable. You can do it, and they're interesting. I've read that decision 3 times, and I cannot see how they came to the decision they came to. Now, here was the one question that they wanted to focus on. Remember, I said sometimes they'll narrow it down to one question. Here's the question. To what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office? The lower court had said there is no permanent immunity for a former president. The Supreme Court shocked a lot of people by saying, wait a minute, yes, there is. And they greatly expanded the scope of what the president could do without being subject to any kind of lawsuit or criminal penalty. And when you get to the part where it says, in theory, that the president, acting in his official capacity, could call in the attorney general, acting in her official capacity, and they could talk about 7 or 8 things, and a couple of them might be illegal matters, actually planning things that would be illegal, violate the law, that would somehow be within the scope of his presidential duties. Whenever I read that, I just want to fall on the floor and bang my head. How is planning a crime in any way a part of a president's duties? I don't get it. I'm sorry. I hate to sound so amazed, but every time I talk about it, I am. But there it is. Okay. Let's look on just a couple more of these, and then we're out of here. The tariff decision, again, I think I kind of tipped my hand on this at the very beginning, but the tariff decision went the way it went because the court said, Mr. President, you forgot your partner on this. Congress is supposed to have a major hand in this. These are not, it's not part of your duty anywhere in the Constitution to do this. It's their duty. So you notice it was a 6-3 decision, which I think shows you that there are at least 3 justices that will vote on Trump's side on anything, because there's simply no constitutional authority for him to arbitrarily be setting, unsetting, setting, resetting these tariffs all around the world without any kind of guidance or agreement by Congress. Another confusing decision is this one having to do with birthright citizenship. Once again, that is in the Constitution. We read it just a moment ago. Wait, maybe we didn't. Maybe we didn't. Hang on a minute. Okay, here we go. Oh, hold on just one second. 14, yes. Yes. All right. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. I don't know how you say it more clearly than that. But the first time I went to the Supreme Court, they kind of ducked the issue. They ended up issuing a decision having to do with whether lower courts could issue nationwide injunctions stopping a certain type of behavior all over the country. And they sort of said, no, you really can't do that. You can do that in your district. You can't control the whole country. That was not what anyone asked them to settle. So that went back into the docket, and it's supposed to come back up and be decided on this summer. So we'll see. And I don't like to make predictions, especially today, but I don't see how you read what I just read you and then say that there is no birthright citizenship in the Constitution. It's just there. I mean, now, could it be taken out? Absolutely. Constitutional amendment could take the whole line out tomorrow. Well, not tomorrow, but in 3 or 4 months. But no one has ever proposed such an amendment. A really important case, I'm going to have to slide over this Kim Wong arc here, but basically that had to do with a Chinese American citizen who left the country for a while to visit his relatives in China, and when he came back, he was denied entrance because they said he was not a citizen, and he went to court, and the court said, yes, he is a citizen. He was born here. This is an important case, and I hope when the decision comes out in a few months, I hope you'll really focus on this and read it, because here's one. It's called Trump v. Cook, and it has to do, the big issue is this. We have all these quasi-independent agencies, like the Federal Reserve, the Federal Communications Commission, Federal Trade Commission, about a dozen of them, that were designed by Congress when they were created to have some measure of independence from the president, from the executive branch, even though they formally belong in the executive branch. That there would be some breathing room, for instance, with the Federal Reserve, where the Federal Reserve chairman or chairwoman could say, we're not raising interest rates right now because we don't think it's good for the economy, and we do not exist on the whim of the president. I'm sorry he disagrees with us. We don't want to raise interest rates right now, and here's why. Well, this decision that's coming up, this Trump v. Cook, having to do with whether he can fire a woman who now sits on the Federal Communications Commission, goes all the way back to the 30s when FDR tried to fire certain government employees, and the court then ruled, no, you do not have the right to do that. They are your employees, yes, but you have to go through Congress in order to get them fired. You can't just blow them off today. So that is a major presidential power question. Whether every single thing that goes on in the executive branch is under the president's control, or whether there can be some measure of independence, as Congress seems to have designed. Those are kind of the big ones. There's a couple of gender rights, transgender controversies coming up having to do with athletes. And there's one case out of Colorado where Colorado has passed a law saying that counselors can't talk about gender transition with young people. That's being challenged on the grounds of freedom of speech, that it chills freedom of speech between doctors and patients. And let's see, is there one other? Those are kind of the, and there's the, can you have guns and be stoned on marijuana a whole lot? That's a Texas case too. And you know what? I won't be surprised if they come back on that one, based on oral arguments the other day, and say, okay, it's all right if you want to smoke marijuana from time to time. You can still have a gun. Those laws were intended originally to protect women and children if you have a sort of a domestic abuse situation and you've got a guy who's out of his mind on marijuana and brandishing guns around the house. But at oral arguments the other day, both liberal and conservative justices seemed to be saying, is that really so bad? Didn't they used to drink a whole lot of liquor back in the founders' times? And yeah, they did, yeah. All right, so anything, I'm sorry, I may have ran on just a little bit here, but can I answer anything? I'm sorry? Theoretically, you could, yes. You would start it by the Congress doing the same thing that it would do in a presidential impeachment. The House of Representatives would bring the charges against and vote on whether to impeach or not, and then it would move to the Senate, and the Senate would decide whether the person could be removed from office. It actually happened to a district judge, I think, in Florida some years ago that was impeached and removed. But
So
yeah.
They could actually remove them. It's not just a political.
Oh, no, you can be removed, yeah. Yeah, otherwise it really wouldn't have any sting. Yeah.
Detention facilities, would they not be the same as the Japanese?
The detention facilities where? The ones they're building now, all over the place. Well, in some, just from some of what I've read, in some cases, these new detention centers may have harsher conditions than the Japanese lived under. I mean, you got. Oh, you're saying couldn't it be attacked legally? Couldn't, yeah. Of course, they're going to say that in some of these cases, especially, that these folks have violated laws and shouldn't be here. And again, we don't know that because we get back to due process. They haven't been through courtroom procedures to determine that. An accusation is not a proof. Yeah.
So in Texas, we seem to pass a lot of laws that most of us seem unconstitutional.
Yeah.
Like posting the Ten Commandments in the classroom. Is Texas known to be like a place where you start a radical law and hoping it makes it up to the Supreme Court?
Well, being the biggest conservative state, being kind of the linchpin of the Republican majority right now, we get a lot of attention, maybe, but there's certainly Alabama, Mississippi, other places have laws on the books just as stark as some of these are. Yeah. Anything else? Yes, sir, ma'am.
Just last night, so I don't know, I don't even get the full picture, but a statue at the Texas Ranger statue
Mm-hmm.
was just unveiled.
Mm-hmm.
And I didn't get the gist of all of it. What is on the base of it just Texas Rangers in general, but I got the feeling that it was a particular Texas Ranger's name was on it.
Mm-hmm.
And supposedly he was a member of the Klan and he was
Yep.
pretty
Yep.
nefarious.
Yep.
So I don't really understand what was it on there and moving forward.
Okay, and the real way to really dig into this if you want to, there was a really good book written by a former morning news reporter named Doug Swanson a few years ago all about this thing. And I bet it's on the shelf here right now, so see if you can find that. But what really comes down to is the mythology that's always surrounded the Texas Rangers, this idea of, you know, one ranger, one riot, that kind of thing, and we'll take care of it. And if you go back into the history of the Texas Rangers, according to Swanson's book, they very often were sort of fighting for white privilege, fighting for the rights of the white majority, and keeping. There's the guy who's supposedly the model for the statue, according to what I read. There's a picture of him somewhere with a black person being hanged in effigy behind him, that kind of thing. So. Again, there's a big piece in the paper about it today. You may have seen, or maybe it was yesterday, by Robert Wolonsky. It's got a lot of details on it. But the Swanson, I remember when that came out, that's really what encouraged them to remove it from Love Field, where it had stood for a long, long time. So, anything else? Yes.
Going back to the Korematsu scenario, just for a second. I wanted to ask you if there's a cloud influence that changes like the weather does. In other words, public opinion and emotion at that time was very, very strong towards I'm going to kill anybody that's Japanese
Right.
or anybody that gets in my way. But it applies to some of the other decisions that have been made here, including Roe v. Wade.
Mm-hmm.
And I was wondering if, in fact, the change in the weather politically, us as a people and so forth, are going to influence the decisions made by the Supreme Court.
Well, that's an interesting analogy, kind of a change of the weather, change of the political weather. As I said, the Korematsu was a triple defeat for democracy because all three branches of government took part in denying these people their rights. As for the Roe v. Wade, you have to keep in mind that the conservative right and the moral majority, as they were called, never liked that decision. They've been against it for 50 years. There's a real good book called Jesus and John Wayne that came out just recently that talks about how this Christian nationalist thing began to build up, and it's not new. It long precedes Trump. He just sort of he's not the wave; he's a bubble on the wave, and that gets into this quite a bit. This idea that people need to they want to set up this idea that Christianity is not some meek, polite little creed. It's a fighting creed. And John Wayne is our symbol, not this meek Jesus you see sitting there with his robes and his beads and all that. And so they want a more macho Jesus. But they've always hated Roe v. Wade, and they've always felt it was wrong. And you have to say one thing about the Republicans: they tend to be more focused on the courts, or at least the right, further right wing, more focused on the courts than Democrats have tended to be over the last 4 or 5 decades. Democrats tend to look at elections and candidates and not so much the inner workings of the court. And there have been people in the conservative movement who, going back 30, 40 years, who were just getting ready for some way of getting rid of Roe v. Wade. So yeah, weather is a good idea. Anybody else? I really have enjoyed. Oh, yes, ma'am. Artificial intelligence? You know what? Of course, they need some kind of intelligence, right? I mean, she's asking if there's any AI-related cases coming before the court. I'd be surprised if there are not some in the pipeline. There's none on the calendar right now on the docket that I know about. But I wouldn't be surprised if next term, for instance, A lot of these are not quite ripe cases yet. They're not mature yet. And I wouldn't be surprised if we see a number of those next year.
Are there any, well, more specifically, tracking people?
Yeah, using AI to track people. Again, that would seem a logical case to come before the court, but I'm not aware of one right now. Anything else? Yes, ma'am.
This is probably a silly question, but who is responsible for enforcing decisions?
Oh, that's an excellent question. Who is responsible for enforcing the decisions of the Supreme Court? And the answer is you, as part of public opinion, and the executive branch and the legislative branch. There is, as somebody once said, the Supreme Court doesn't have the power of the sword, meaning they do not have their own police force or their own military, and they don't have the power of the purse, meaning they can't take money away from people and fine them and all of that. So what the Supreme Court has lived on really is trust, is people saying, okay, we didn't vote for these people exactly, but we believe that they're there for the law. We believe they're doing the best they can. And to the extent that the court gets politicized and they began to be seen as politicians who just happen to be wearing black robes, that is really bad for the court and not good for the country either. But they do not have any enforcement mechanism. After the 55 Brown v. Board desegregation decision, most of the South just ignored it. They said, we're not doing it. That's where you had these white flight schools springing up, you know, and schools, cities that would close down their swimming pools rather than integrate them. You know, so no swimming this summer, kids. And the Supreme Court didn't have any power to go in there and say, open that pool. So, yeah.
This voucher program to me is very, voucher program to me is very scary because then they become their own little entities in their private schools. They can keep people out. We're going to be right back where we were before with the segregation issue, with the religion issue.
Yeah.
And to me, the democracy, the beauty of this country to me is that we all get the right to choose how we pray, who we love, as long as we care about
Yep.
each other.
Mm-hmm. Yep.
And we don't hurt other people.
Mm-hmm.
This is becoming very extreme, and that's
To go back to the book I just mentioned, this Jesus and John Wayne, it really, oh yeah, good. And it shows you how long that movement has been building this idea of we don't really want to be one country. Why would we want to be one country with a bunch of satanic weirdos over here, you know, who don't even respect gender? And so that's why you see such contempt today in the Trump administration, starting with their press secretary. You see, you debate with people you respect. You give reasons to people you respect. Otherwise, you say, shut up. You're evil. You hate America. Shut up. And that's a lot of what's going on is they've moved one part of the population over to these others that we really don't want to deal with. And that's not good for anybody. Not good. Yes?
You said privacy is definitely included in the framework of the Constitution. But one thing that's been going on since for over a year now is our data is being certainly not respecting my privacy.
Yeah.
That issue is close to being addressed.
Well, and they've had a chance to address it for 20-something years now. I remember it was 20 years ago, I think it was Larry Ellison of Oracle Computer who said, would people quit whining about their privacy? You have no privacy. We've got all the information about you we need. And that was 20 years ago. But how you stop that, I simply don't know. Somebody once said, you want to know who really knows a lot about you? Your pharmacy, your mail carrier, and your doctor. Put those three together, and that's a lot of stuff about you right there.
Europe has been enacting protection for privacy most of my adult life.
And I think that's
one of the things that our previously liberal tech bros used to complain about.
previously liberal. Yeah. Oh, well, doesn't Europe even have, several European countries have a thing where if you want to disappear from the internet, they have to take you out. They have to wipe you out of it. We don't have anything like that here. Yeah. So
at the present time, it's basically the government trace me anywhere. Anybody can trace me anywhere. I no longer believe it's a matter of I just don't do what I'm not supposed to do.
a couple of chilling examples of that came up, no pun intended, with these ICE raids up in Minnesota, where they knew the names of certain protesters and all, and knew where they lived and everything, just like that. I mean, that's scary. That is not something you want to get much stronger than that. As for whether there'll be a Supreme Court case brought that brings all this together and deals with it, again, I'm not aware of one right now, but I wouldn't be surprised if one comes. And I hope they will decide something good on it. Anything else? Thanks so much for coming out today. Really enjoyed it.
Since I'm here, I'm not gonna mail it to you.
Oh, okay.